Good morning, everyone, and welcome to the 12th day of this session, 68th Wyoming Legislature Budget Session, February the 22nd, 2026. Members, if you would please get ready. Our reading clerk will take the roll. John, please proceed.
Convening roll for the 12th day, February 23rd, 2026. Alamand. Andrew. Angelos. Banks. Bear. Brady. Bratton. Brown Gary. Brown Landon. Byron. Campbell Elisa. Campbell Kevin. Chestick. Clouston. Connolly. Davis. Erickson. Filer. Fornstrom. Geringer. Haroldson. Harshman. Heiner. Heft. Jarvis. Johnson. Kelly. Excused. Knapp. Knapp. Larson Lloyd. Larson JT. Lawley. Lean. Locke. Lucas. McCann. Nicholas. Ottman. Pendergraft. Posey. Provenza. Briggins. Rodriguez Williams. Schmid. Sherwood. Singh. Smith. Storer. Strock. Stivar. Tarver. Thayer. Washit. Washit. Wasserberger. Webb. Weber. Worf. Williams. Williams. Winter. Wiley. Yin. Mr. Speaker. Geringer. Gugamas. Got him already. Yep. Anybody else? Storer. That's it, isn't it? Williams.
Oh, Kevin, sorry.
Campbell. Kevin. Mr. Speaker, 59 present, 3 excused.
Thank you, reading clerk. Next, ladies and gentlemen, I'd like you to stand and remove cover. Our prayer is going to be led by Pastor Marty Crump from Family Life Church in Gillette, Wyoming. In the gallery, please join with us. Pastor Crump, please.
Thank you, sir. Mr. Speaker, members of the House, thank you for the honor and privilege of being able to do this. Would you pray with me? Heavenly Father, we thank you. You are the God of the universe. You have made us. You know us. You know everything that we are and all that we do. Father, you said it is in you that we live and move and have our being. And you are interested in the affairs of men. You raise nations up and you take them down. Father, I thank you for being able to pray for this great body, for all of these representatives who have sacrificed their times. Thank you, Father, for their families. Ask your blessing upon them. Father, I thank you for allowing us to live in the best state, in the greatest nation in the country, in the world. Father, you have given us this privilege and this honor. And so I pray for this esteemed body and ask in the name of Jesus that you would give them wisdom, discernment, and strength, and even patience with each other. Father, I pray peace over this house, over the things that are done, that you would just move in your might and in your way, and that you would encourage and strengthen each and every member that is here. I pray for the speaker and the leadership and all of the committee members and all of the LSO staff, everyone that does this, that makes our state work. So Father, we just thank you, ask your blessing upon this day and this week, and I just worship you. In Jesus' name we pray. Amen.
All members of the desk, please join. Okay. All you got to do is get to a microphone. Representative Bratton, you have something?
Thank you, Mr. Speaker. Yes, I do. I rise today to note that this week is Wyoming School Board's Appreciation Week and to recognize the men and women who serve on local school boards across our state. In the North and in the West Gallery are many of our school board members. So I'd ask you to rise and recognize many of our school board members who are locally elected public servants who give countless hours, often quietly and without recognition, to the governance of our public schools. They balance budgets, set policy, listen to their communities, and make difficult decisions with one guiding principle, ensuring that Wyoming students receive a quality education. Their work reflects a long Wyoming tradition of local governance closest to the people, civic duty, and stewardship of public institutions. On behalf of this body and on behalf of the communities they serve, I ask you to join me in thanking Wyoming school board members for their leadership, their service, and their commitment to our students and to our state. Thank you.
Thank you for all being here and welcome to the House. And you also, all of us know there's some major legislation that is being brought through this chamber right now and is in the other chamber. We do appreciate you being here and being willing to take time to speak to these legislators, to help them to know and better understand the situations that each one of you individually face. And in so doing, it will help us to be able to come with a product that our hope and trust would be, and that it was something that will, as we go ahead, will be something that is workable and is good for the people of the state of Wyoming, especially our youth. And so thank you for being here. Thank you for taking times out of your schedule to come and chat with us and oversee this process. And let's work together to come up with something that's going to ultimately be a good product that will last for hopefully years to come. So welcome and thank you for being here, all of you. Okay, next, our Journal Committee report. Yes. Oh, yeah, you have some, Representative Filer, please.
Thank you, Mr. Speaker. Can I have a quick privilege?
If you see fit.
I think these school board members might enjoy this a little bit. Folks, why was the music teacher locked out of her classroom? Her keys were on the piano.
Thank you, Representative Filer. Okay. Should we try a Journal Committee report? Please. Journal Committee report.
Your Journal Committee reports that the Journal of February 21st, 2026 has been read and recommends that it be approved. Representatives Posey and Jarvis.
Thank you, Reading Clerk. And our doctor of the day is Matthew Strang, MD. He will be here with us. And so if you guys are making sure that you're feeling good, stay hydrated, eat, keep yourself nourished. It's been a long couple of weeks we've been through here, and we've got 2 more of them maybe to go, a little more potentially, who knows? But it's important that we stay on the floor. I do have 3 members, 2 of which are under the weather today that are not going to be with us. And so keep them in your prayers, as well as Representative Kelly, as he is preparing for surgery for his back. And so we don't want to lose any more of you. So let's be very mindful of our health and how important it is, and get plenty of rest. And hopefully this week's coming will allow us to do that. So thank you all for being here, and thanks for the doctor to spend the time with us and look after us. Page of the week, Sydney Gough, G-O-U-G-H. Oh, Goff, Sydney Goff. See, I would have never spelled it really well either, because that's, okay. Well, welcome to the House. Senate Chief Clerk's granddaughter. And so she's over here to help us today in the House chamber and is going to be working with us. So welcome to the House. Look forward to working with you and look forward to being able to hopefully, there's things you may learn here. There's things you may not want to learn here. So we're just impressed that you're willing to be here. And so, but thank you for being here. We look forward to working with you. All right, ladies and gentlemen, as we move through next, unless there's something else here, Senate files on first reading. First one we need to introduce here, ladies and gentlemen, is Senate file number 1, reading clerk.
Senate File 1, sponsored by Appropriations.
First reading of the bill.
General Government Appropriations.
Pursuant to Joint Rule 14-1E1, Senate file number 1 is referred to committee number 2, appropriations. That is the Senate budget bill. So we're back into that. Okay, ladies and gentlemen, next thing we have here is go on to our, we got first reading bills. So we got first reading Senate files on introduction. First Senate file for consideration is Senate file 27, reading clerk.
Senate File 27, sponsored by Senator Landon.
First reading of the bill.
Leash dogs for tracking black bear.
Senate file 27 will be assigned to committee number 6, travel. Next Senate file for our consideration, Senate file 39.
Senate File 39, sponsored by Senator Crago.
First reading of the bill.
Long-term homeowner tax exemption, sunset repeal.
Senate file 39 will be assigned to our committee number 3, revenue. Next Senate file for our consideration is Senate file 43.
Senate File 43, sponsored by Senator Hicks.
First reading of the bill.
Conservation District Supervisor Contracting.
Senate file 43 will be assigned to committee number 5, agriculture. Next Senate file for our consideration, Senate file 44.
Senate File 44, sponsored by Management Council.
First reading of the bill.
Gambling Amendments.
Senate file 44 will be assigned to committee number 3, revenue. Next Senate file for our consideration, Senate file 46.
Senate File 46, sponsored by Management Council.
First reading of the bill.
Skill-based amusement games, licensed liquor establishments.
Senate file 46 will be assigned to our committee number 3, revenue. Next Senate file for our consideration, Senate file 57.
Senate File 57, sponsored by Senator Brennan.
First reading of the bill.
Transparency and hospital service pricing.
Senate file 57 will be assigned to our committee number 10, labor. Next Senate file for our consideration, Senate file 67.
Senate File 67, sponsored by Senator Larson.
First reading of the bill.
Wyoming State Guard amendments.
Senate file 67 will be assigned to committee number 8, transportation. Next Senate file for our consideration, Senate file 71.
Senate File 71, sponsored by Senator Olson.
First reading of the bill.
Wyoming Department of Homeland Security.
Senate file 71 will be assigned to our committee number 1, judiciary. Next Senate file for our consideration, Senate file 88.
Senate File 88, sponsored by Senator Salazar.
First reading of the bill.
Sex offenders, residents near child care facilities.
Senate file 88 will be assigned also to committee number 1, judiciary. Next Senate file for our consideration, Senate file 107.
Senate File 107, sponsored by Senator Nethercott.
First reading of the bill.
Motor vehicle registration and plate issuance system.
Senate file 107 will be assigned to our committee number 8, transportation. Next committee, Senate file for our consideration, Senate file 122.
Senate File 122, sponsored by Senator Dockstader.
First reading of the bill.
Medical necessity standard timeline amendments.
Senate file 122 will be assigned to our committee number 10, labor. Next and last Senate file for our consideration, Senate file 124.
Senate File 124, sponsored by Senator Driscoll.
First reading of the bill.
Economic Development Rodeo Museum.
Senate file 124 will be assigned to our committee number 6, travel. We have messages from the Senate. Please, reading clerk.
Message 153. Mr. Speaker, the bill listed below passed the Senate on third reading in an amended form by the vote indicated. Senate File 1, General Government Appropriations. Ayes 20, noes 10, excused 1. Message number 154. Mr. Speaker, the Senate adopted the Committee of the Whole report failing the bill listed below by the vote indicated. Senate File 118, Eminent Domain Water Projects. Ayes 9, noes 17, excused 5. The bill has been indefinitely postponed. Sincerely, Ellen Thompson, Senate Chief Clerk.
All right, ladies and gentlemen, we have your reports from our standing committees. Reading clerk.
Senate File 4 is sponsored by Labor. Medicaid rate increase EMS services, an act relating to Medicaid, medical assistance and services. Mr. Speaker, your committee number 10, Labor, Health, and Social Services, to whom is referred Senate File 4, Medicaid rate increase, EMS services. Respect the report, same back to the House with the recommendation that it do pass. Ayes, Representatives Clauston, Ottman, Rodriguez-Williams, Thayer, Yin. Noes, Representatives Guggenmoss, Heft, McCann. Excused, Representative Wasserberger. Representative Rodriguez-Williams, Chairman. Senate File 6, sponsored by Labor. Eligibility for Medicaid criteria, an act relating to medical assistance and services. Mr. Speaker, your committee number 10, Labor, Health, and Social Services, to whom is referred Senate File 6, engrossed. Eligibility for Medicaid criteria. Respect the report, same back to the House with the recommendation that it do pass. Ayes, Representatives Clauston, Guggenmoss, F, McCann, Rodriguez-Williams, Thayer, Yin. Noes, Representative Ottman. Excused, Representative Wasserberger. Representative Rodriguez-Williams, Chairman. Senate File 9, sponsored by Judiciary. Fentanyl to minors, enhanced penalty, and act relating to controlled substances. Mr. Speaker, your committee number 1, Judiciary, to whom is referred Senate File 9. Fentanyl to minors, enhanced penalty. Respect the report, same back to the House with the recommendation that do pass. Ayes, Representatives Brady, Bratton, Chestick, Filer, Lean, Singh, Washit, Webb. Excused, Representative Kelly. Representative Washit, Chairman. Senate Joint Resolution 1, sponsored by Select Federal Natural Resource Management, State Management Federal Mineral Leases, a joint resolution requesting Congress to introduce a bill and enact law to amend the Federal Mineral Leasing Act to authorize the state of Wyoming to administer and manage mineral leasing on federal lands located in Wyoming. Mr. Speaker, your committee number 9, Minerals, Business and Economic Development, to whom is referred Senate Joint Resolution 1, engrossed, State Management Federal Mineral Leases. Respect the report, same back to the House with the recommendation do pass with the following amendments. Ayes, Representatives Campbell, Heiner, Knapp, Larson, Lawley, Riggins, Tarver. Excused, Representatives Schmid and Weber. Representative Heiner, Chairman.
Thank you, Reading Clerk. Next, ladies and gentlemen, we'll be moving into our bills on second reading.
Mr. Speaker,
Oh, yes, Representative Bear, please.
privilege of the floor, please.
You certainly may, please.
Thank you, Mr. Speaker. Ladies and gentlemen, I would like to point out that we have a new goldenrod. You should have gotten that in your boxes, and I'm going to ask that you hold on to this for a few days. Your JAC, your HAC, your House Appropriations Committee, will be getting a brief on the Senate File 1, and then we will be bringing that information to this body. And when we do, I'd like to go over this in more detail. I just want to give you kind of a 30,000 foot where are we at based on the information that I have so far. But I'll say that right now that our House Bill 1 looks to be, at least in general funds, about $100 million, $113 million below the governor's recommendation. And the Senate file is about 53 million above the governor's recommendation. So we're sitting right at about $160 million difference in general fund dollars. And when it comes to other funds, we're very, very close on those other funds. So really the main difference is going to be on general funds at about $160 million difference. So we'll be working on that this week, and I will be bringing an update. Hopefully we'll be able to focus on really just the differences, so we won't have to spend a long time going through the entire bill, but really just the differences. And if you'll notice the notes at the bottom of this goldenrod, please read those in advance. I'm not going to sit here and read them to you, but they really show some differences in the funding models between the two, how we funded some of our spending. And those are going to be things that the JCC will need to negotiate through. But if we were to come to agreement on those differences on funding models, we're really about $45 million apart, the House and the Senate. So very close. There's really, I have a high expectation that we'll be able to come to an agreement with our brothers and sisters down the hall in a quick matter. So thank you for letting me give you an update, and look forward to giving you more details in the coming days.
Thank you, Representative Bear. Representative Lawley? I know.
Thank you,
thought
Mr. Speaker. I move second reading amendment.
Hey, wait, no, I thought you were just going to do a privilege. I got to read them in first. Yeah, we got to do, but thank you for your
Good morning,
enthusiasm.
Mr.
Yeah,
Speaker.
let's hang on to that because we're going to want that. Okay, second reading bill for our consideration is House Bill 103. Reading clerk.
House Bill 103, sponsored by Representative Ottman, Wyoming First Amendment Protection Act, an act relating to civil procedure.
We have amendments. Representative Lawley, do you have an amendment?
I would, Mr. Speaker.
Oh,
Thank you
please.
so much.
Sure, welcome.
I mean, no, I can't talk. I move second reading amendment number 1 to House Bill 103. And let me just say generally what this does, and I want to talk a little bit about why it does it, and then I'll come back and go over the specifics of the amendment. Basically, what the amendment does is it creates an exception for defamation from the SLAPP bill. I think SLAPP bills are important, and they do an important thing in the space of protected First Amendment speech, which is where they should do the space. And in fact, the title of this bill is Wyoming First Amendment Protection Act. So with that in mind, let me just give you a little background. First of all, every state that has a SLAPP bill has some version of an exemption or exception for defamation. And here's why. It is well settled in the law that while the First Amendment protects a broad range of speech, it excludes specifically defamatory statements. Courts have historically ruled that the right to free speech does not allow individuals to harm others through false statements. So again, this is something that's already exempted out in some ways, but we need clarity in this law because we're making some significant shifts in rules of procedure, the way normal due process works in our court system for these First Amendment protections. But defamation, false statements against someone else is not protected speech under the First Amendment. So that's what the bill does and why it does it. And as I said, other states have these exceptions. They can do them in a couple different ways, nuanced ways, but in effect, they acknowledge this reality politically that defamation is not protected by the First Amendment. I'm sorry. So let me go through the amendment with you so you can see how we did it working within the way the bill was currently structured. We talked about this actually last year as well, but and the bill was written slightly differently, which made it an ability to just say, that there's an exception for defamation. But this one, I tried to work with what was done. So if you'll go to page 5 of your bill, line 19, where if you go up to 18, it starts with the immunity from suit granted in this section. I've stricken may be overcome, but I put does not apply if a person's conduct is knowingly false and defamatory or was made in a reckless disregard for the truth, including willful ignorance or refusal to investigate, which is kind of the definition of what defamation is. And so then I've done one other thing on page 6. I've taken out the F paragraph because it's unduly restrictive for anyone that's under this exemption. It basically says that anyone asserting immunity, because this is more set up like an immunity thing, may overcome the immunity asserting under this section by presenting sufficient evidence that an exception under E of this section applies, provided the court shall not weigh competing evidence unless the parties have waived the right to a jury trial. So this is kind of holding hostage the truth and being able to make your showing that this is defamation, because you have to either agree to not have a jury trial in order to get this, or get this what they call kind of an exception or a overcoming immunity, unless you agree that the judge can't weigh competing evidence. I let that sit on you a minute, because it's really an important procedural thing that this is saying, that if you want to have the immunity here, which we've lined out with what amendment I've just made, you can't really get it unless you agree to not have a jury trial. Or if you want a jury trial, they can't hear any evidence contrary to what is being claimed. So this is not a good idea. I would even argue in general, but for this idea of defamation, let's just make defamation a clear exception. Let's have the SLAPP law that really does what it's supposed to do, which is protect that constitutionally protected free speech under the First Amendment. But defamation is not protected under the First Amendment. So let's reflect that here. because that part of the law will not be upheld because we are where we are, and it's long held truth that defamation is not protected by the First Amendment. I ask for your aye vote on this amendment.
Thank you, Representative. Representative Chestick, for your first time, sir.
Thank you, Mr. Speaker. I rise in support of this amendment. I think, I can't remember if it was during testimony in committee or in the hallways afterwards, but I learned that a lot of states have anti-SLAPP laws, and a few of them have had some constitutional challenges, and it's always been about this paragraph. The attempt to coerce somebody into waiving their right to a jury trial has caused constitutional concerns in other states, and that has been held unconstitutional elsewhere. Let's pass this bill without that in it to make this bill stronger and more likely to survive a challenge.
Thank you, Representative. Representative Ottman, for your first time.
Thank you, Mr. Speaker. Yes, I would say these amendments, this amendment may seem innocuous, but it eviscerates this bill. I would hope that this is not what the representative from the biggest of the horns intended. Changing may be overcome to shall not apply completely reconfigures the rights, turning this from a presumed immunity, a substantive right, into one that has to be determined whether it applies or not. As written, this bill gives Wyomingites a presumed immunity, automatic, presumed, for your First Amendment, and a substantive right. If someone wants to pierce that right, they must bear the burden of overcoming it. Shall not apply flips that. Now we are not asking the plaintiff to overcome anything. We are asking the court to decide whether that right exists at all. That turns a right into a question, which is something we do not want to do. Here in Wyoming, we presume our rights. We don't beg for them. And those who wish to take them from us should be the ones asking permission. The second change is even worse. Deleting the paragraph on page 6, lines 7 through 12 does two things. Both of them are disastrous. First, it strips out the evidentiary standard that tells courts what a plaintiff must show to defeat the immunity. Without it, every district court in Wyoming invents its own standard, sowing confusion, masquerading as clarity. Second, it removes the only provision protecting the right to a trial by jury. That paragraph ensures that a judge cannot weigh competing evidence because that is the jury's job. Unless both parties have waived their right to a jury trial, that will not happen. Removing it creates a serious tension with Article 1, Section 9 of the Wyoming Constitution. This body has no business creating that problem. I heard the trial lawyers lobbyists claim in committee that this paragraph would require a waiver of the right to jury trial. Read the text. It does precisely the opposite. A judge may not weigh the evidence the parties have waived during the trial. That protects the jury right. It does not threaten it. I urge a no vote on this amendment and a yes vote on the bill.
Thank you, Representative Ottman. Any other members for their first time? Representative Lean, you are back by no, not on this one. Okay, any other members for their first time? Second time, Representative Chestick, you good? Back to the bringer. Representative Lawley, please.
Thank you, Mr. Speaker, and thank you for the discussion. But the bottom line is defamation is not covered by the First Amendment. So if this bill is about First Amendment protections, how can an exception for defamation gut the bill? It really rises in my mind to say, what are we trying to do here, hiding behind the words First Amendment? Because the bill does do a lot of good things for protected speech, and I support that. But we have Supreme Court precedents going back a long way saying defamation is not protected by the First Amendment, full stop. So the argument it decimates the bill is either wrong or there's something hidden in the bill that is an intent beyond protecting First Amendment speech. This amendment does not stop the protection of First Amendment speech. And as I said, states that have SLAPP bills have this exception in it. So I really do urge you to say aye to this amendment so we can actually support this bill. Thank you.
Thank you, Representative. Body, you are voting on second reading amendment number 1 to House Bill 103. All those in favor signify by saying aye. All those opposed, no. Amendment has not been adopted. Okay, next amendment for our consideration is to House Bill 103, amendment number 2. Representative Heiner, please.
Thank you, Mr. Speaker. I bring you second reading amendment number 2 to House Bill 103 and ask for your favorable consideration. This amendment does two things which I believe will strengthen the bill. First, it adds a new exception of defamation of private figures. This bill, as introduced, requires a plaintiff to show reckless disregard of the truth to overcome the immunity. And that's the correct standard for public figures, but it shouldn't be for private individuals. Our highest court of the land ruled in a case that private individuals who are not involved in matters of public concern need only show negligence. And this amendment aligns the bill with our constitutional net framework that was determined by our highest court. Without this, the bill arguably gives some individuals more protection than the First Amendment requires, and it does so at the expense of ordinary Wyoming citizens who are genuinely defamed through negligence. So I don't think that's what the bill was intended, and that first part of this amendment fixes that. Second, it replaces the evidentiary procedure in subsection F. I know this section has created quite a bit of confusion as we have discussed this bill throughout the different committees and discussions. The new language resolves that confusion by defining exactly what the court may consider when ruling on an immunity motion. So the pleadings, the motion, any response, and supporting affidavits and declarations, nothing else. No mini trial, no discovery battle, no live testimony. Since this is now dealing with just the immunity motion, there is no need to touch on the concept of jury trial. So that right remains unaffected, as I believe was initially intended on this bill. The new language specifies that disputed facts are viewed in the light most favorable to the non-moving party. That's the standard Wyoming lawyers and judges already know for the summary judgment practice. So it protects both sides. The immunity claimant gets an early determination on a defined record, and the plaintiff gets the benefit of the doubt on contested facts. So I think this amendment will alleviate some of the confusion and conversation that's been going around about this bill, and it makes it a stronger bill. I urge your favorable consideration.
Thank you, Representative Heiner. Representative Ottman, for your first time, please.
Thank you, Mr. Speaker and members of the House. I would say that I agree with this amendment. This amendment resolves all of the confusion that has been put forth previously, and in a manner that fully preserves the intent of the bill. So I would just say, please vote aye on this amendment and also aye on this very important bill. Thank you.
Any other members for their first time? Thank you, Representative. First time on the amendment. Seeing none, I'm assuming back to the bringer. He waves us off. Ladies and gentlemen, you are voting on second reading amendment number 2 to House Bill 103. All those in favor signify by saying aye. All those opposed, no. The amendment has been adopted. Okay, are there any other amendments? We good? All right, House Bill number 103, having been read 2 separate times, question is, shall the bill be read a third time? Hearing no objection, it is so ordered. Next bill for consideration will be House Bill 126.
House Bill 126, sponsored by Representative Nyman, Human Heartbeat Act, an act relating to public health and safety.
We have amendments. Representative Yin, please, sir.
Mr. Speaker, I move second reading amendment number 1 to House Bill 126 and ask for your favorable consideration. So members, we have before you this bill that purports to say that we shouldn't be allowed to have abortions after a heartbeat is detectable. Frankly, I think we've heard during committee of the whole some of the discussion that this is going to be considered unconstitutional. Frankly, just because of the same reason that the other laws were considered unconstitutional. And so I'm trying to bring forth another policy option that will be considered constitutional. When it comes to a heartbeat bill, one, heartbeat is a political phrase, not a actual medical phrase when it comes to pregnancy. And two, a woman might not even know that she's pregnant by then. And so to say that it's outlawed before she can even know that she is pregnant, I think makes it almost more unconstitutional than the previous abortion bill is. The amendment I bring before you enacts what's called the viability standard. So that's the standard where we know that the fetus is actually viable outside of the womb. So you no longer have to rely on a woman's bodily functions for that pregnancy. And that separates the decision between what is a woman's health care and what is not a woman's health care, and what is a reasonable restriction and what is not a reasonable restriction. Again, I would argue that turning doctors into felons is never going to solve our maternal crisis. Every bill that we do that does that makes everything worse. I changed this into a misdemeanor, get rid of the felony, and ensure that we trust our medical providers when they are providing healthcare to the women in the state. What I would argue again is let's not waste more time just to have something suspended in court for another year, another 2 years. Every time we pass a bill, let's just do the right thing and make sure that we can actually have and raise families and have young people stay in the state of Wyoming. Thank you, Mr. Speaker Pro Tem.
Representative Gugemas for your first time.
Thank you, Mr. Speaker Pro Tem. Fighting for human life is not a waste of time. Just wanted to clarify that. Thank you.
Anyone else for their first time? Speaker Nyman for your first time.
Thank you, Mr. Speaker Pro Tem. Appreciate the bringer. I understand what he's wanting to try to do, but you know, to me, the argument that we are somehow wasting time or just, you know, hey, we're just looking for ways to keep the court entertained. It doesn't work with me. I guess the reality of it is courts can get it wrong. They can. I mean, let's look at, can you say it? Can I, you can't, maybe it's not mentioned here. It's when people were allowed to own each other. It was all right to own a man or a woman who had a skin color that was not white. And the Supreme Court of this land said, yep, we're okay with that. It's good. Was that right? Did the court get it right? No. No. Beyond all, no. So the idea that we're somehow trying to avoid, you know, contention or problems, and the fact that we're somehow believing that if we just leave this well enough alone, that we would save everybody a lot of money, that doesn't work. The Dobbs decision clearly said that in 1973, the court got it wrong. They said abortion is not a right. To be able to terminate the life of an unborn baby is not a right. And they said, and so to prove that, we're going to turn it back to the states. We're going to let each one of you states decide what limitations you want to put on that. And that's what we're doing, ladies and gentlemen. That is the right of this body, whether, you know, how we see that coming up and how we see that being handled is the right of this body to make that determination, clearly enumerated in our state constitution. So, I mean, if the argument here is that we're trying to avoid litigation, then that same argument should have compelled the court to stay the decision that they made back then when they said it was okay to own somebody that was a different color skin. It was wrong then. That determination is wrong. This determination was wrong, and it was proven by the way it was overturned and allowed the states to come back. Now they're saying, let the states decide this. So viability, I mean, if you want to go down the viability lane, let's be honest. If I had a baby that was born, is it viable? Is it sustainable? If no care was given to it, would that baby make it? I've got a 2-year-old grandson at home that's, if you want to use those, he's going to have intervention from somebody else to help him be viable. If he was a year old, if he was 3 months old, if he was 2 months old, is he viable? No. He has to have help. He has to be fed. He has to be cleaned. He has to be kept warm. He has to be maintained. And he's not viable. Not from that definition. He would succumb to whatever elements that he was presented with because nobody was taking care of him. Now, my 11-year-old grandson, that boy there is viable. He can do it. He can shoot clay bird bustingest machine in the world, but he's 11, people. So if you're going to talk viability and the ability to be able to protect ourselves, what is viability? And if that viability is going to be left up to a physician that's going to say, yeah, this baby's viable, this one's not. No, a heartbeat, I believe, is a line that we can draw. When that little pump starts working in there and is moving circulating blood out through the body, that means that little person is at that point of development. That's a line in the sand. So I would push back against these amendments. I would reject this. I think we do have a right to do what we're doing. Courts have proven that. They have stated that. They've compelled us as a state to make those determinations. The representative from where Chief Washakie is recognized made that argument the other day. We have a record. We need to make sure that we continue to develop that record and stand on what our rights are as a state, and that's to protect life. And we can make that determination here, and I would encourage us to do so and push back and reject this amendment. Thank you.
Representative Chestick for your first time.
Thank you, Mr. Speaker Pro Tem. I'd like to remind the body of comments I made during Committee of the Whole on this very bill, on this point, that right now, today, in Wyoming, abortion is fully legal up to late term. And the bill this bill changes that to a heartbeat standard, which, as the good bringer of the amendment points out, is not a medical term. The medical community is very divided over when the noises you're hearing are actually a heartbeat or just some electrical activity leading up to the development of a heart. It's unclear. The science is unclear. But the point is that this bill creates a standard that is essentially existing, the law that existed prior to the bill that was ruled unconstitutional. So this bill would be held constitutional. I am very confident of that because it basically reinstates the ban on abortion that existed prior to our recent attempts to expand the ban. I think this actually does provide protection. It would make late-term abortions illegal, which they should be. After viability, that's what I would call late term. That's when there's a reason for doing that. The viability standard is a reason which satisfies the reasonability part of Section C, Article 1, Section 38. Therefore, it would satisfy that part of the Constitution. So enacting this amendment would give us a bill that actually does ban late-term abortions. If without this amendment, I think it's very likely that the court would find it unconstitutional again and enact an immediate stay, and we'd still have another year or more of Wyoming allowing abortions up to late term. And therefore, I think this is a safer way to go. It actually would be held constitutional, and I would recommend an aye vote.
Anyone else for their first time? Representative Pendergraph.
Thank you, Mr. Speaker. Pro tem viability. At what point does a senior citizen become so dependent upon help that they are no longer viable? At what time does a child with a severe brain development become no longer viable? I ask that. Say no.
Representative Sherwood for your first time.
Thank you, Body, and good morning. You haven't heard me speak publicly on this issue because I believe it is an extremely personal decision. However, I signed on to this amendment because my constituents want exceptions for rape and incest. My constituents want to vote on a constitutional amendment on this issue. But this bill does neither of those things. As it stands, this bill is a violation of our personal freedoms. And because it does not provide the considerations that my constituents are asking for, I'm a no vote on the bill and an aye on the amendment.
Anyone else for their first time? First time, second time. Anyone for their second time? Speaker Nyman.
Thank you, Speaker Pro Tem. I guess, as far as the rape and incest part of it, quite frankly, I don't think there's a differentiation. I think incest is rape. Whoever propagates it, to do that incredibly vile act. I mean, but here in the situation, the allowance is here for almost 3 months of opportunity if that act happens. The ability of that person to be able to end that pregnancy, even though it is no fault of the baby in how they were conceived. Quite frankly, that's one of the biggest struggles I have with this, is because that little person's life is going to be ended even though they didn't get to choose how they were conceived. But now this bill gives them a right to do that for, almost the first 3 months of their life. So I do believe there's been consideration for that in this, in an effort to try to bring some kind of, I don't know how you could even say balance to it, but I mean, reality, I don't know. I mean, you guys all know my position is, where does life begin then? Some believe it's when you leave the womb. Some believe it's a conception. I personally believe it's a conception. This bill does not allow protection for that baby from conception. This bill allows it only after its heartbeat is detectable. So I do believe there are opportunities for people to be able to utilize this. I know it's a difficult thing, but ladies and gentlemen, this is a life. And we're trying to make sure that that beating heart can continue to beat. So on and against.
Anyone else for their second time? Second time to the bringer. Minority Floor Leader Yoon.
Mr. Speaker Pro Tem. So members, we do always have the last word after the court has their say. The last word is passing a constitutional amendment. If that's the policy that you want, pass a constitutional amendment. What this will do is do what, frankly, all of you argue shouldn't be done, which is leave the law ambiguous after the court case. Because what will happen, again, is that it will be in court, tied up, stayed, and our law will continue to be ambiguous. We have a way to not make it ambiguous with this amendment. When the good speaker talked about how our country thought something was wrong, we passed a constitutional amendment. But that's not what we're doing here. What we're doing here, again, is tying up the courts. I also heard the speaker talk about making sure folks are viable after birth. I think we should do more of that. I frankly don't think we do enough of that. And I think in our budget, we have a little bit of a reflection of how that isn't necessarily our priority. We also think that the court does certain things wrong with school recalibration, for example. But we are responding with a bill or with the budget amendment with an ECA that we think brings it to address the concerns that are brought upon the court case. What the bill does doesn't do that. All the bill does is create another unconstitutional law. The viability standard makes sense. It's what we've had in law for very many decades. Let's put it back. Thank you, Mr. Speaker Pro Tem.
Thank you. Ladies and gentlemen, we're voting on second reading amendment to bill number 1. We're reading on second reading, we're doing second reading amendment number 1 to House Bill 126. All those in favor, please say aye. Opposed, no. That amendment has failed. Next amendment for our consideration is second reading amendment number 2, Representative Larson Lloyd.
Thank you, Mr. Chairman. I'd like to move second reading amendment number 2 to House Bill 126. Folks, if you go through the bill and at the bottom of page 7 and on top of page 8 where the penalties apply, this is applying to the Board of Pharmacy. So if a pharmacist receives from a doctor a prescription and fills that prescription, that's generally how that works. And so as I'm trying to figure out why the pharmacists would be liable or be culpable in this bill, I was struggling with that connection. So I just propose that we move pharmacists out of this section. I think when they call the pharmacist to prescribe the drug, he isn't required to make the determination if there's a heartbeat or whatnot. I don't think that the intent of the bill is to be punitive to in the process unless there's been the people in making that determination actually do an examination and determine if there is a heartbeat. So that's the intent of this amendment, is to just remove the penalties to the pharmacist.
Representative Chestick for your first time.
Thank you, Mr. Speaker Pro Tem. I rise in support of this amendment as well. The other thing that a pharmacist doesn't know when they're asked to fill a prescription is what the drug is going to be used for. Why was it prescribed? Many of the drugs that are used in abortions have other purposes, other functions. They're prescribed for other reasons. And the pharmacist does not know what that reason is, why the prescription was written the way it was, and should not be asked to inquire further. That would be an invasion of privacy.
Chairman Rodriguez-Williams for your first time.
Thank you, Mr. Speaker Pro Tem. On and opposed to the amendment. The good sponsor of the amendment said he was trying to find out why there's penalties in here and wanted to remove them. I urge the body to keep the penalties in there. Chemical abortion is the #1 method of aborting a preborn baby. It's the most popular method. And I believe that if a pharmacist is responsible, a responsible pharmacist, they would tell the patient or the person that they're speaking to what risks come along with it. I think it's important for women to be fully informed of what risks are posed when they do take those pills, of what's happening. And in this case, there's a second life that's ending. And so if there's no fully informed consent when that is being handed over to the patient, there has to be some sense of liability. So on and opposed.
Chairman Brown for your first time.
Thank you, Mr. Speaker Pro Tem. I absolutely 100% agree with the informed consent portion, but I'm really concerned about, and I'm literally trying to wrap my head around this idea that we're going to punish the person that is not prescribing the medication, but is just distributing. These are medical orders. So when they come, a pharmacist does not have the authority nor the capability of writing a prescription and providing this drug to induce an abortion. They don't have that authority. This has to become a medical order from a medical professional that has the authority underneath not only state law, but federal law, and also the rules that govern their body. So if they're told, if there is, and trust me, I agree with them. I don't like the idea, and I've looked at the research on this as the number one way abortions are performed as well. I agree with that. But that's not the pharmacist's fault. The pharmacists are doing what they're ordered to do from a medical professional's standpoint. So now what we create is a potential conflict of professionalism between a doctor of medicine and a doctor of pharmacy that says, you shall prescribe. And the pharmacist says, well, I can get in trouble for that, so I'm not going to give this. I honestly don't know what kind of discussions or conversations can ultimately happen to get in a position where we can hold a pharmacist liable. And do we hold them both liable for this drug, the actual prescription being filled and submitted? I agree with the chairman of Labor Health. I get that we don't want to have these drugs distributed, but I don't know that creating felons out of the pharmacists prevents that. And so I'm probably going to be an aye vote on this amendment, but only for the simple fact that I think that it muddies the waters when we start talking about creating multiple felons. And if we want to create a felony on the doctors and go down that path, I'm fine with that. Let's have that discussion. But when we're creating this for the person who is actually just doing the distribution of the drug, not the prescription, the distribution, I get a little concerned about whether or not we would be violating, if the doctor says you shall do this and they don't do that, does that go against their code of ethics on what the doctor told them to do? I don't know. They're directed to do something. So I'm torn on this amendment. I appreciate the bringer bringing this forward, and it actually maybe muddies the waters a little bit more. So a little bit of discussion on this would be helpful for me. Thanks.
Chairman Washut for your first time.
Thank you, Mr. Speaker Pro Tem. I strongly support this bill, but I'm struggling with trying to comprehend how the pharmacist knows whether or not this prescription, even if they know it's being written for an abortion, how would they know whether the pregnancy is pre-heartbeat or post-heartbeat? How would the pharmacist know that information? And if somebody can explain that to me, I might change my mind on this amendment.
Representative Conley for your first time.
Thank you. I think this is a good amendment. I don't know that we can say all pharmacists don't talk to the people when they hand them a prescription, because I know with the prescriptions that I've had to take over the years, the pharmacist would call you off to the side and he'd say, now here's the contraindications, here's the side effects, here's what this drug does in case you didn't understand what your doctor was prescribing. So I don't think we need something that holds pharmacists, fine them, make them criminals when they're just doing their job. So it's lumping a lot of people into one bag, and that's just not right. So thank you.
Representative McCann for your first time.
Thank you, Speaker Pro Tem. As a provider, I've had pharmacists call me and say, we probably shouldn't do this for whatever reason. They do it all the time with narcotics. This, in my mind, actually protects the pharmacist because it gives him an excuse to say, no, I'm not going to fill that out, or anything along those lines. But they are able to say no. They are not required by any law per se to say you have to give this prescription because I, as a provider, said so. Just want to make sure that's clear. Thanks.
Representative Brown Gary.
Thank you, Mr. Chairman. The problem that I find with the argument from the representative from House District 9 is that, I'm sorry.
Can't do House districts. Can't give the House district.
Okay.
Yep. So
Mr. Chairman, the problem I find with the argument from the representative from my county is that during COVID, when doctors were prescribing ivermectin, for instance, for COVID, that pharmacists were refusing to fill those prescriptions. And so therefore, the pharmacists were overstepping at that time. And so now we look at this and our argument is, well, the pharmacists don't have a choice because the doctor has prescribed it. And the doctor prescribed ivermectin, but yet the pharmacist took a choice. They decided not to do that.
So just to remember, ladies and gentlemen, on each one of the podiums, you're going to find a list, and we can use county numbers, we can use county names, but we can't use district numbers. Speaker Nyman for your first time.
Thank you, Speaker Pro Tem. Ladies and gentlemen, I would ask, I just learned about this amendment this morning and had a good visit with the representative. And I would ask this, let's reject this amendment. Let me have a chance to go back and do a deep dive into this and what we can do to try to provide those protections that he's looking for. But come back with something that is going to be better structured and do this tomorrow. Give me a chance to kind of get with some folks that can do a better job of really in this. I want to do this right, ladies and gentlemen. I don't want to just slam and ram and jam and cut and slash. I'd like to do this right. So if you would give me that opportunity, I'd greatly appreciate it. Let's reject this amendment. Give me a chance to bring back a third reading, maybe amendment. We'll do some discussion and see what we can put together tomorrow. So.
Anyone else for their first time? First time, second time, Chairman Brown.
Thank you, Mr. Speaker Pro Tem. So I appreciate that, and I appreciate the speaker's willingness on this, because what we've seen in the past, especially on bills that are this meaningful and have this much heart put into them and have such a large impact on this, is that these discussions were not had in good faith. And we would push through a bill on this side and we'd get it down to the other side, they'd amend it, and the exact same amendment would be ran over there, and it would come back here for concurrence, and we'd say, oh, it's the best thing we could ever do. Let's get this passed. So I appreciate that we're going to have some good faith discussion on this and that we're going to actually have this. I hope we actually see it. Because what I also heard was during some of our budget discussions, we were going to see some cleanup budget bill or some amendments that did not make it through. And so I take the speaker at his word on the fact that we're going to see this and we want to work this through and we actually want to have this done right. So I appreciate that. And I tend to agree with it. Let's vote this one down then. Let's see a good amendment on third reading.
Chairman Rodriguez-Williams.
Thank you, Mr. Speaker Pro Tem. On and against, again, the amendment. Appreciate the good words of the rep that works in the medical field. And I'll just remind the body that pharmacists have a code of ethics. I took a look at it, and one of the bullet points in that code of ethics states that a pharmacist respects the autonomy and the dignity of each patient. And in this case, there's a human being in the womb. a second patient. Nowadays, preborn babies can undergo surgery in the womb and have their own surgeon separate from the mother, on and opposed.
Anyone else for their second time? Anyone else for their second time? Second time, no. Back to the bringer, Representative Larson Lloyd, bring us home.
Thank you, Mr. Speaker. I'd just like to say that I agree with the good chairman of Labor and Health when she says that the pharmacists ought to explain what the risks are and everything associated with the drug, and I think that they do that. That doesn't apply in this bill as far as I can see. They do explain it. Who's picking up the prescription? I don't know the last time I picked up my prescription. My good wife does that, and I'm sure, but inside the package is an explanation of what the risk and what the drug is used for. But they don't, in this case, they don't necessarily know if this is a drug used for a chemical abortion or if it's used to manage blood pressure in somebody with diabetes. And I think that is one of the other uses for the drug. There's other things they can do with that, but they're not really making the determination that the person should have the drug, or that's determined by the healthcare professional. Yes, they can call. I don't argue that. I just don't think they fit into that. I agree, and I'm not trying to make this bill, I'm not trying to destroy the bill. I just don't think this fits in it. So with that, Mr. Chairman, I would respectfully withdraw this amendment, and let's see if we can get this figured out and make sure that these people aren't being unduly scrutinized.
Thank you, Representative. Without any discussion or objection, the amendment has been withdrawn. Okay, House Bill 126 having been read two separate times. The question is, shall the bill be read a third time? Hearing no objection, it is so ordered. Okay, ladies and gentlemen, next we have,
Mr. Speaker.
yes, Representative Angelos, please.
Mr. Speaker, can I have a privilege of the floor?
You certainly may. Proceed.
All right. Joined in the South Gallery. Did I get that right, everybody? South Gallery.
Yes, that is south.
We're joined by the State 4-H leadership team. And I'm going to name off their names here. We have Addie Vasic from Albany County, Ray Leonhardt from Bighorn County, Elise Neff from Campbell County, Colt Walker from Sublette County, Shay Zelihai from Campbell County, Michaela Workman from Bighorn County, Selden Little from Campbell County, and 28 other 4-H members and UW educators from across Wyoming. And thank you for all your support. If you could give them a hand.
Thank you for being here. 4-H, I tell you, that was a major part of my life growing up, and the ag advisors were always cruising, looking for those 4-H kids that they could sweep into FFA because they were so well trained and they were so good at what they did, learning livestock judging and everything else that went with 4-H. But 4-H, ladies and gentlemen, just for your edification, is one of the most broad-based, multifaceted opportunities for young people in the United States. They offer everything from home ec to shooting sports to all livestock, everything. And their efforts in 4-H are incredible in helping young people get engaged in their futures. And so if you can, by all means, your county fairs are full of them. Go down and see these young people and the work that they do. Parents are heavily involved in 4-H, and it is a tremendous asset to the state of Wyoming. So thank you guys for what you do, and appreciate your continued support of 4-H in Wyoming. So glad you're here. Next bill for our consideration, unless I've got, nope, Ms. Jarvis, she's up. Next bill for our consideration will be on second reading, House Bill 159. Reading clerk.
House Bill 159, sponsored by Representative Lean, safeguarding personal expression at K through 12 schools, an act relating to education.
Okay, we have amendments. Representative Jarvis, if you would please proceed.
Thank you, Mr. Speaker. I move Committee of the Whole, second reading.
It'll be second, I move second
Sorry.
reading amendment number.
Sorry, I move second reading amendment number 1 to House Bill 159 and ask
Perfect. There
for
you
your favorable consideration.
just right. Proceed.
So as we went through this bill, there were a couple glaring concerns on how the bill kind of expands protections beyond some of our federal, state laws. And what this, I think it's really important to understand first and foremost, that states cannot unilaterally override federal constitutional doctrines that are inconsistent with federal supremacy principles. So basically, we can't write state statute that overrides federal statute. But here's where this bill becomes really interesting, because we also can't write agency rules that override statute, and we can't write school policies that override agency rules or state statute. And we can't write school procedures that override school policies, so school board policies. So it's really important to understand that, because what this bill does is it gives the right to the student to override all school procedures and school policies that are in place. And it allows them to not have to follow them when it comes to freedom of speech. And in three specific areas: in religion, in the political arena, and here's the one that gets really, really sticky fast for schools: ideology. What does ideology mean? It means ideas and ideals. So we have Title 21 that exists, where schools are required by state statute to create board policies in school discipline, school board authority, curriculum control, and anti-bullying policies. When you consider that, this gives the right to the student to actually override all of those. I'm just going to let you think about that for a minute. It gives them the freedom to override those. And then when you look at it, guess where in procedures, what sits in procedures in most school districts? Dress code. So as a high school principal, I used to have a no-goes box. And I used to tell some of my students, reach for the sky, touch your toes. If anything shows, it's a no-goes. And if something showed, you need to go get yourself some clothes out of there until your parents can get you some clothes that you need. You've removed our right to have no-goes boxes, sorry. Tread lightly, because this bill was intended to override school policies and school procedures. And this creates a really tough situation if a young human being comes in and says, I have an idea or an ideology that I want to dress provocatively, and oh yeah, you can't infringe on that. Because this policy, or this bill, does talk about clothes, clubs, organizations, freedom of speech. It exceeds the ability for us to protect our children and keep them safe. So I ask that you consider this amendment, because this amendment specifically says this bill will not override federal law, state agencies, rules, school policies, and school procedures. And then the only other amendment that's made in here is that on page 4, line 21, it's delete during, and that I ask that this not give students the right to impede on instructional time of the schools. So, and it's just specifically dealing with clubs and organizations, but it would give the right to extend the ability. So like during class, if I wanted to go have a club meeting with people, the school district would have to allow that to occur. So it really truly is just tightening this up so that we can keep students safe, but we can also honor their freedoms, because truthfully, these already exist. We have the freedom of speech. So, and I don't think schools are going to push back on religious or political. I think where the pushback, that ideology word, gets really sticky really fast. Thank you.
Thank you, Representative Jarvis. Representative Lean for your first time.
Thank you, Mr. Speaker. On and opposed to the amendment, well, let's start with a couple of reasons. The very first one is that under the construction of the U.S. Constitution, we find the freedom of speech and freedom of religion, and this bill is helping to guarantee our students that authority. It is our duty to write the laws, and therefore our agencies and our governmental entities under that to be able to write their rules and policies according to the laws that are set and the constitutional guidelines. So we're well within our bounds to do that. I couldn't find any specific laws that are being thwarted through this, so I would ask if you could name a specific law. That would be wonderful for us to, as a body, to be able to digest. And this doesn't impose that school districts cannot set modesty, sexual content, or profanity against their dress codes. This has nothing to do with that, and that school districts could still maintain those policies. There's many school districts that already have policies in place to deal with disorderly conduct, harassment, bullying, and modest dress codes. These policies should not infringe on the First Amendment of free speech, and if they do, they're already in need of redirection immediately, and this bill helps to produce that. Please vote no on this amendment and aye on the bill. Thank you.
Representative Bear for your first time.
Thank you, Mr. Speaker. I believe I heard the good bringer of the amendment say that the First Amendment really doesn't trump school policy, and that can't be. And I would say I have often stood here and spoken about the importance of us as elected officials taking on the responsibility of reducing the amount of rules and policies that our departments have to produce. The reason being, we're accountable to the people. They are not. They're trying to get the job done that we put before them. And so we should always be writing our bills and hopefully our laws in a way that reduce the amount of rules and procedures. And by all accounts, I cannot imagine that our doing so takes away anything that is more powerful than our Constitution and our statutes. So on and against the amendment.
Thank you, Representative. Any other members for their first time? Seeing none, second time. Back to Representative Lean, second time.
Thank you, Mr. Speaker. I would also like to add that in this bill, it talks about instructional time and discussion. So when class time is open to discussion, it gives the teachers the ability to listen to all ideological views of students and not force them to believe one way or the other. And as far as club times meeting in the middle of class, that's absolutely not able to happen, because the school district could say that the clubs are able to appear within the boundaries of their school district and within specific schools, but they still have the ability to monitor when they meet and how often they meet and what teacher is overseeing that club. So it would not be in the middle of instructional time, and therefore I ask for a no on the amendment.
Thank you, Representative. Representative Jarvis, or let's see, Representative Bear, would you like a second? No, we're good? Okay. Representative Jarvis, please, ma'am.
Thank you, Mr. Speaker. I believe I did name this statute, and it was Title 21, where it asks school districts to create policies and procedures in these specific areas. It asks them to create them, again, I will just say this, let me find it really fast. School discipline, school board authority, curriculum control, anti-bullying policies. And then some districts have dress codes that sit in policy, and some have them where they sit in procedures. And that's where you see the parent-student handbooks. Those are procedures. So, and that typically is the guidelines that talk about what students can and cannot wear. for the appropriateness. At no point did I ever say that we can trump the freedom of speech in any circumstance. What I did say is federal law trumps state law, so it overrides state law. State law overrides rules. Rules override school policies, and school policies override procedures. And if there's ever a point where that doesn't happen, that is 100% within anyone's right to file a legal complaint and get that changed, because they just cannot do that. What I am saying is this bill gives students the right to not follow policies and procedures, and technically even like if you want to pull in our Wyoming High School Activities Association, they can choose not to wear the uniform because it infringes on my ideology. This bill exceeds those things. That's why I'm asking for your favorable consideration in these amendments. And if a policy or a procedure does exceed any constitutional right, you have the ability to bring that to the forefront and force change. Thank you.
Thank you, Representative Body. We are voting on second reading amendment number 1 to House Bill 159. All those in favor signify by saying aye. All those opposed, no. Amendment has not been adopted. House Bill 159 having been read 2 separate times. The question is, shall the bill be read a third time? Hearing no objection, it is so ordered. Okay, ladies and gentlemen, moving on to third reading. Regular list. First bill for our consideration is House Bill 39. Reading clerk.
House Bill 39, sponsored by Representative Washit. Firearms rights, restoration amendments, an act relating to crimes and offenses.
Okay, we have amendments. Representative Washit. Please, sir.
Thank you, Mr. Speaker. Members, we've explained the purpose of this bill before. We did find that there was a minor issue with a little ambiguity with regards to other rights, such as serving on a jury, voting rights, those sorts of things. The purpose of this bill is specific to firearms rights. And so what this amendment does is it makes it clear that this is only affecting firearms rights, and that nothing in this change shall be construed to restore rights as an elector or a juror or to hold office of honor in the state of Wyoming, even if the state back home where you had your rights restored gave you those privileges, that unless you otherwise qualified for those privileges under Wyoming law, this change today only affects firearms law, firearms rights. So that's what this amendment does. Please support it.
Representative Washit will need you to move that amendment. Please, sir.
Thank you, Mr. Speaker, for that reminder. I move that when the
I move second reading amendment.
First reading amendment.
Second reading.
Second reading amendment
Third
number
reading,
1.
actually third, yeah.
Third reading amendment number 1. I move amendment number 1 to this bill.
Thank you. There we go. All right. We got all the amendments moved now. All right. Any discussion on the amendment? Seeing no one, Representative Washit? You good? All right. He's waving us off. Members, you're voting on third reading amendment number 1 to House Bill number 39. All those in, let's see, this is for final and passage. So members, we're going to do a roll call. No, just amendment. It's just amendment we're doing. Then we do the roll call. Members, all those in favor signify by saying aye. All those opposed, no. Amendment has been adopted. Okay, now, House Bill number 39 having been read 3 separate times. The question is, shall the bill pass? Assistant Chief Clerk will please call the roll.
Allemand, Andrew, Angelos, Banks,
Bear, Brady, Bratton, Brown Gary, Brown Landon, Byron, Campbell Lisa, Campbell Kevin,
Excused.
Chestick, Clouston, Connolly, Davis, Erickson, Filer, Fornstrom, Geringer, Guggenmoss, Haroldson, Harshman, Heiner, Heft, Jarvis, Johnson, Kelly excused, Knapp, Larson Lloyd, Larson JT, Lawley, Lean, Bach, Lucas, McCann, Nicholas, Ottman, Pendergraft, Posey, Provenza, Riggins, Rodriguez Williams, Schmid, Sherwood, Singh, Smith, Storr, Strock, Stivar, Tarver, Thayer, Washit, Wasserberger excused, Webb, Weber excused, Wharf, Williams, Winter, Wiley, Yin. Mr. Speaker, are there any changes? Are there any changes? Closing vote. Vote closed. 58 aye, 4 excused.
House Bill 39, having been read 3 separate times that have passed the majority vote of the members that elected to the House, House Bill 39 has passed the House. Next bill for our consideration will be House Bill number 52. Reading clerk.
House Bill 52, sponsored by corporations, elections, hand counting for recounts, an act relating to elections being enacted by the legislature of the state of Wyoming.
All right, we have amendments. First amendment for our consideration is a big one. Representative Brady, please proceed.
Thank you, Mr. Speaker. I move third reading amendment number 1 on House Bill 52.
Perfect. Please proceed.
Colleagues, we're all familiar with election issues nationwide, as well as within our state, our own state. It's becoming more evident the matter of foreign influence in our past elections, and we have no assurance that that foreign influence will not continue to do so. To correct that and to ensure foreign influence does not take place in any of our future elections, it's imperative we return to hand counting of ballots to eliminate any and all questionable violations of outside influence, such as mentioned, to protect our sacred vote. Hand counting paper ballots is the only trustworthy method to ensure every vote cast goes to the intended candidate. This bill will verify election purity. There's a healthy grassroots movement whose purpose and mission are to educate and train the process of hand counting to hundreds of citizens around the state in the preparation of hand counting. These grassroots citizens also provide input into the drafting of this amendment to ensure it is thorough and solid. In fact, these same citizens testified during interim and session times. Due to their valuable knowledge provided to our legislators at these meetings, those on the committees were able to conduct several days of discussion going over the various issues the different county clerks had with the electronic voting machines. All over the state, people are preparing for hand counting paper ballots in the event they are needed. If our commander-in-chief signs an executive order mandating hand counting, or when we as a state pass legislation to return our elections back to paper ballots and hand counting. These training courses have taken place all over the state. I personally have attended 3 training courses in Southwest Wyoming alone. In fact, a constituent was so impressed with training that took place in a city really close to the Utah border, that she wanted to host a training in the river that's green. Smurf contacted me stating she wanted to get involved and organize a training course for her network of friends, family, and business associates, as she understood the need to educate voters that hand counting of ballots is the only way to ensure election purity. That's how it happens, one proponent at a time. There's an awakening happening across the country to the concern of the validity of our elections when using electronic machines. This bill will ensure all 23 counties follow the exact same procedures. Wyoming elections should rely on processes that can be observed, audited, and replicated by citizens using the gold standard elections by which hand counting would take place. This bill also upholds the Wyoming Republican Party platform's commitment. Oh,
We
I can't say
can't, yep,
Republic.
no.
This bill also upholds a majority party's commitment. That, okay? Thank you. That elections are to be secure, transparent, and trustworthy. I ask for your aye vote.
Thank you, Representative. Any members for their first time on the amendment? Representative Washut.
Thank you, Mr. Speaker. As I consider this, I think about really large counties like mine and what this process would look like when we're talking about thousands and thousands of ballots. You know, many years ago, I worked a case where we caught some thieves and they'd stolen a massive amount of packages of cigarettes in a burglary. And we counted those cigarettes because we had to put it in our report, how many packages of cigarettes were recovered. And every time we counted, we got a different number. And one officer would count and come up with one number, and I'd count and come up with a different number. And it was frustrating, to say the least. I think the bill is good, has much going for it, but I think this amendment takes us back to a highly problematic approach that doesn't work uniformly well in all of our counties. I'd also just like to comment that when members read their testimony at the microphone, it causes me some pause to wonder, are we hearing testimony from the representative or from someone else? And so I just encourage all the members to speak your heart when you come to the microphone. And I know it's not easy for everyone to articulate your thoughts, but working from bullet points and an outline is a much better approach at the microphone than reading your testimony.
Thank you, Representative. Representative Riggins, for your first time, please.
Thank you, Mr. Speaker. I would ask the bringer of the amendment, one question would be, how long do you think it would take to get the results and have them delivered to the Secretary of State's office? Second thing I would comment, I've participated in this exercise before, and it was probably only, I don't know, 400 or 500 votes, and we did have minute errors. And I'm thinking that's just a few precincts, one or two precincts, right? You have volunteers in these exercises. When they go through this process one time, how many volunteers will you have the next time you try to go through this process? I would vote against this amendment. Thank you.
Speaker Nyman, for your first time.
Thank you, Speaker Pro Tem. I did it. I went through one of these trainings. Ladies and gentlemen, this can be done. I know, I mean, I don't want anybody to have her to burst into flames, but the reality of it is I got caught up in a deal. We had, ballots being counted by machines. It eventually got sorted out. We went through the process. It was not an easy process, but we got through it. My election here 2 years ago was kind of a lot of the catalyst that drove this desire to do this, because the truth is, ladies and gentlemen, if my race would have been contested, you could easily have just watched that election disappear into the ether. The only reason that mine was caught is because it was uncontested. And it was such an anomaly that it raised red flags. And the red flag I got was from a non-constituent in the center part of the state, called me at 1 o'clock in the morning and said, how in the world is that possible? Well, in the situation, it went right on through the system and was said, okay, we're good. Should be no problem. It's a protest vote. Wouldn't that make sense? There was a misalignment in the ballots. I mean, we're working through that process. I get it. But the reality of it is, ladies and gentlemen, a hand count would have caught that. Bingo. And so, there's been a lot of testimony out there about, this is going to be impossible to do. How are you going to get enough people to do it? It's just too onerous. It's just too much. But when I went down and went through a training, there was redundancies to the point of the good bringer over here, or the good representative from the center part of the state. There were series of people that if somebody was miscounting, they would stop. They say, okay, is everybody here at this point now? So one guy here is like, no, I'm missing one. Okay, then we've got that set. We're going to go back here right quick. We're going to double check and make sure everything's right. We got back. Oh, yeah, I marked the wrong one. Okay, we're all good. Everything's confirmed. Then let's keep on trucking. They were doing races that had picked 3 of 5. They were marking them all down. We went through all different kinds of scenarios. And I will tell you, there were some people there at that training that were very apprehensive. They're like, I don't know if I want to mess with this or not. But by the time they were done being shown how to do it in that situation, in that system properly, they said, I'd love to do this. This is simple. This is straightforward. This is just this, and everybody is, watching and taking care and double checking. And we were smoking through ballots like you can't believe. And they were all confirmed. There was no concern about whether or not they were marked or anything like that, or dark or whatever. Voter intent, all that things. All the things you see about it. So, I mean, I'm speaking on this in support of this because paper ballots could have saved a lot of heartache in my situation. A lot of heartache. And ladies and gentlemen, it does scare me that a line error in a computer in a situation like that, where even in other races in my area up there were, pick 2, they had to go back and they had to change votes between those electeds. And those were only checked because mine was brought to the forefront because it's such an anomaly. Again, I would challenge all of us to realize that if my election, which I'm sure I'll probably seldom ever have another unopposed election, this ought to be interesting, but in that particular case, I think that we have an opportunity to realize this is not a perfect system by any stretch. And how many of us go when there's quite that difference, they'll go back and they'll challenge the election if I would have had a competitor. We just said, well, I guess that's just what the people wanted. And I wouldn't even have asked. But when you can darn near lose an unopposed race, there might be some real reasons for us to say that maybe we can do a better job of making sure that the people's vote is being assigned to the person that they wanted. Because that is one thing I will leave you with. I had a gentleman call me and he said, I have been disenfranchised as a voter. I'm like, what do you mean? He said, I know I voted for you and my vote was not counted for you. So, ladies and gentlemen, to just say that this is just too much and it's too onerous and that it's too difficult, there are methods in place. This can be done. And what more important thing, ladies and gentlemen, can we put our emphasis toward is making sure that your vote counts and that your vote matters and that your vote is applied to the person you wanted it to be applied to. So those are the things you need to be wrestling with. It's a big amendment. It's a big change. I get it. But hand counting ballots can be done. Yes, it is going to take work and commitment on the part of the voters. Why is that a bad thing? It's only going to be the difference in leadership, who you're going to be represented by for the next potentially 4 years. So on and for the amendment. This can be done, ladies and gentlemen. Yep, it's a job, but it's a job worth doing.
Representative Davis, first time.
Thank you, Mr. Speaker Pro Tem. I like to always look back in history. You know, at one time, this is the way we did it, was hand counting. But what was the issue that caused us to go to electronic counting? Was it the errors back then? So just food for thought, you know, history sometimes repeats itself. So that's the question I'd like to bring up here for thought. Thank you.
Representative Thayer, first time.
Thank you, Mr. Speaker Pro Tem. So House Bill 52 was brought by joint corporations. I'm not sure why they worked this bill. We had an amendment on committee of the whole. They worked with the Clerks Association, and now we have a 21-page amendment. I mean, I'm just baffled that there's a lot of time and effort spent. And I appreciate the good bringer of this amendment, but it's just, what was wrong with the bill we've looked at the last few readings on and against this amendment?
Chairman Brown for your first time.
Thank you, Mr. Speaker Pro Tem. Ladies and gentlemen, I've got to echo the same sentiments of the previous speaker, only because this is another bill resurrected, and that's fine. That's what we do. We get to do this. But my concern with this, I looked at rules, I checked on this. It all falls within the rules to do this. So I think it's very clear that this body, we understand that this is what we do as we debate these types of ideas. But my problem with this is the implication. What I heard the original bringer of the amendment is this gives the entire state of Wyoming identical rules to follow. And I have really, really serious qualms with that. And that is only because all of Wyoming is not homogeneous. So I pulled up some statistics here really quick just to kind of try to find out registered voters in different counties. And we range everywhere from Niobrara County being 1,600 voters, which I would think this would be a very easy process for 1,600 voters to be hand counted, to 5,500 in Sublette County, 3,800 in Hot Springs, 8,000 in Bighorn County. Then we start getting into some of the bigger counties. You start talking about Fremont County, reigning 25,000 voters. Get into Sweetwater, you got 20,000 voters. Teton County, you've got 17,000 voters. And then Laramie and Natrona County, you're somewhere in the range of 60 to 70,000 voters apiece. That's my problem with this amendment. If we give the opportunity to county clerks to do this, and the county clerks are elected, and they say, hey, look, we're going to move to this and we're going to have paper ballots, and the people of that county say, yeah, that's what we want, fantastic. That county clerk should be held responsible for what happens in there and how that occurs. But when we change the policy and we say every county is going to do the exact same thing regardless, and we're going to go down to something that completely and drastically changes this, I don't like the idea that we paint a broad brushstroke across the state of Wyoming. I don't disagree with the speaker's comments that we probably have some areas that need to be taken care of. But I'm going to remind everybody, if you go back and watch some of the conversation that happened during the joint conversation during the interim here, was the error rates on electronic voting machines, which my county uses because we have 60,000 people casting votes. The error rate of counting 60,000 votes on an electronic machine is less than 0.1%. When you go back and you look at the error rate that is caused when it's hand counted, it was somewhere in between the range of 1% and 3%. That's a vast and stark change. I understand there's black helicopters flying around about electronic voting machines, ladies and gentlemen. But I trust my elected representative here, whom I don't always agree with, mind you, but I trust her to make sure that our elections are fair and that they're counted correctly. And if we need to recount them, fantastic. But going to paper and pen ballots, pretty sure everybody in this body, minus maybe one of us, was alive and watched what happened down in Florida during the 2000 elections with hanging chads. That's why we went digital. And that old saying that everything is old is new again, I don't think we want to go back to the old way of doing elections unless the county has said they want that and the clerk has said they want that. Give the freedom to the clerks to do what they need to do. Resist this amendment. This was a well-vetted process, and this is going to cause massive issues, at least in the two biggest counties in the state, and maybe that's what it was caused to do.
Any representative? Representative Campbell, please.
Thank you, Mr. Speaker. On and opposed to this amendment and also seeking some clarity, I think, because I've heard two different concepts in my mind, paper ballots and hand counting, that I don't think are the same thing. And the reason I ask for that is in my county, in Natrona, we have paper ballots. So we are given a paper ballot that has your name, your district, all of the information. We verify that with our identification. I take the paper ballot, I fill in my circles, and then I put it into a machine to count. And as the previous speaker said, the margin of error is pretty impressive. So what I'm hearing in this amendment is that we're going to take those paper ballots that we already use, and instead of having the machine count them, we're going to have people count them. And as was mentioned, in one election, we may have 34,000 ballots, 34,000. And that's when not all of us show up to vote. So if we could provide some clarity, because I'm hearing both. We need to have paper ballots, we need to have hand counting, like, in my mind, they're not the same issue. We do use paper ballots, and we do have a machine that counts them. So it sounds like we're just focused on the counting part, which is what I think this amendment does. And if that's the case, I'm absolutely opposed to this.
Thank you, Representative. Representative Larson, JT, for your first time, sir.
Thank you, Mr. Speaker. On and against the amendment, members, I have great concern for our county clerks who already have a hard enough time finding people to be election judges, let alone now trying to find the manpower it would take to hand count, and especially in our larger counties. They're already begging people to show up and help with the election. And in some cases, they can't find people for certain areas. So then they have to send staff to those areas to fill in where they're falling short. So I just think this is a really huge lift for our counties. And I don't want to put that burden on them. So as of right now, on and against, unless my concerns can be addressed.
Thank you, Representative Larson. Representative Connolly, for your first time, please.
Thank you, Mr. Speaker. My concern is that I think it was last year that we had a bill similar to this. And I think our clerks had said that they needed time to train and plan and prepare. But now this particular version, I'm not sure that gives our clerks the time to plan, train, and prepare. And so I'm concerned about that. I think this is going to be a big election cycle, and I don't want to throw the clerks into some kind of a situation where they're trying to do what legislation tells them to, but yet get them in just such a terrible turmoil predicament. In some of our clerks' offices, like in my district, don't have that many staff people to be able to get this all spun up in time. So I would be against this. At least we need to let the clerks have some time to get their head around it. And there may be an opportunity to have a test program to test this out and see how it could work. And I'd be all for that. Thank you.
Thank you, Representative Connolly. Representative Harrelson, for your first time, sir.
Thank you, Mr. Speaker. You guys, this is an interesting conversation, isn't it? So this is what I want to say a couple things about this. Number one, last year, I kind of made this a point with this original bill to bring in a hand count audit type conversation. Right now, current statute that we have gives us zero ability to touch ballots after they run through a tabulator, and that's wrong. That's foolish. We need that opportunity. With that being said, the machines that we have could potentially have problems. We just heard from the good speaker that there are potential problems. I'm not disagreeing with that at all. The concern that people have is there's concerns about their licensing. There's lots of concerns, and I hear those concerns. The concern I have is if we're not careful and we move the needle too fast, we could break the system. And when we start talking about a full hand count in some of these races with the number of candidates, with the number of opportunities, with the number of options, with the amount of training required, all by this summer, I'm concerned by that. Last year when I ran this, my thought was, give us a vehicle to start walking this road out, getting an idea what this looks like, getting our head wrapped around it, proving that this is something we can do, seeing what the volunteer base looks like, and then moving the needle, and then asking a very honest, real question, where do we go from here? And I've said this time and time again, and I'll say it again, I would love to see the current machines leave and a dumb machine come. And this is why. I mean, in the 1930s, we had tabulators that were just simply that. They were just a tabulator. Should we do hand count audits to make sure that tabulator works? Absolutely. I think that's wisdom. And this is it, you guys. I know that having this conversation, I'm making everyone mad. I've got hand count people in my district that I love dearly, I respect dearly, and they're like, Jeremy, you're wrong. I've got clerks listening to this right now that are saying the same thing. You guys, this is probably the hardest. You know what? I thought gun bills were easy after I got done with this one. Because when we walk this out, we have a serious issue we have to address. Is this bill in its current form the answer? I don't know. I've got people saying, no, it isn't. I do know this at least starts the process where we can have a conversation of what hand counting looks like. And if we take and we put a 24-page amendment on there, what we get is what I would describe as rebuilding the engine 3 minutes before you do your drag race. We would be telling our clerks, you got to roll right into an election year and completely change how you run an election. Now, they may be able to do it, and maybe there will be enough people to step up and stand in these places. But I'm afraid that what we're going to get is we're going to get an election day, and we will not have enough people on the ground to make reality out of this. And when that takes place, this is what's going to happen. The general populace will step up and say, why is it that we don't know the results of our election? You want to talk about screaming of election fraud? When it's a week later before we get the actual announcement of what happened in these races. And in small counties, and I'll say this, in my county, that won't be the case. But there are counties that may be the case. And so I believe that there are amazing men and women that are in this battle saying we need to look at these machines. And I believe that they're absolutely right, we do. But I think that if we're not careful, if we go too far too fast, what we have in turn is a broken system. And then we will never get hand counting again because people will say, see, it didn't work. Instead, what I would ask is this, can we measure it in? Well, in turn, will these machines no longer be on the terror of our state in time? Maybe so. Let's have that conversation after we prove that we can hand count audit a race, after we show that this works, after we prove that intentionality and that work. The other thing is this, to get the amount of volunteers we need, I'm afraid we're going to have to do something like jury duty. because that's the amount of volume in some of these counties. The county I stand in right now, there's not a mass movement of people saying this is what we want. And that's a concern because this is this is the largest county and has the most votes. So how do we do that? How do we do that? So the good bringer of the amendment, her and I talked the other day. I don't disagree with her concerns that we have to address this. I wish we would have addressed it last year. Then we would be hand counting this year. We would have been doing that, but this didn't get pushed through the pipeline in that way, and it didn't get the backing it needed. I'm frustrated in that because I am trying to find a way where we can get both and do it in a way we don't break the system. So I will say that I'm against this amendment, and I know I'm in trouble for saying that with a lot of people, and you need to hear my heart. It isn't that I don't want to see it fixed. I just want to see it fixed, not broken.
Thank you, Representative. Appreciate that. Representative Lawley, for your first time, ma'am.
Thank you, Mr. Speaker. On and against the amendment. My chief concern relates to the fact that this amendment completely changes the bill. And our Good Corporations Joint Committee worked really hard to listen to feedback from the public, from clerks in particular, and the bill represents that product. And this completely changes it without the input of those folks. And we do represent those folks, and they have some concerns. I know my clerk cannot support this. They could not make this happen. They couldn't make it happen as this amendment is currently written. So my biggest concern is vote no, because it changes the bill way too much without us having any public input. Thanks.
Thank you, Representative. Representative Geringer, for your first time.
Thank you, Mr. Speaker. I would say I really appreciate the comments of the representative from my hometown. Made a lot of great points. Wanted to add just a little bit to that. One of the things that concerns me in terms of timing, it's pointed out this could take multiple days to get this done. The fatigue that happens for the folks doing the hand counting that's a serious concern. We understand ourselves as the days wear on that fatigue happens and mistakes can be made. I also noticed that there is provision in there that would allow the top election official in the state to allow counting ahead of the polls closing, early counting. That's of serious concern to me. We start counting before the election is finished. What kind of repercussions could happen from that? It refers to an entity in the bill to provide guidance, a private organization. It's in the bill, so I'm going to say it refers to uscase.org to provide guidance, a white paper. So any future revisions to that standard are automatically incorporated by statute. That's of big concern to me. So I guess I would just say the bill started out as just an audit, which I was in support of. Now changing to a full hand count for everything. And there is merit to continue to discuss that, but I don't think this amendment is it. Thank you, Mr. Speaker.
Thank you, Representative Geringer. Representative Williams, for your first time.
Thank you, Mr. Speaker. An election in the northeast part of the state was referenced yesterday that had a question, or earlier today, it had a question mark above it. I'd just like to remind everybody, I was on that ballot also with the good speaker, and the question mark was not due to machine malfunction or machine failure. The question mark over that election was due to human error. Just food for thought. I'm not sure this is a step in the right direction, this amendment. I'm against this amendment. Thank you.
Thank you, Representative. Any other members for their first time? Representative Brown, Gary, please, first time, sir.
Thank you, Mr. Speaker. Mr. Speaker, when I first registered to vote when I was 18, a long time ago, and it was all Back at that time, it was all hand-marked ballots and hand counting. And I was voting in the same county that my colleague from my same county here was born in. At that time, there were over 45,000 registered voters in that county. And we were getting those counted before 10 o'clock in the evening. So I stand in favor of this amendment. Thank you.
Thank you, Representative. Representative Locke, for your first time, sir.
Thank you, Mr. Speaker. And I'm kind of echoing previous speaker's note. I'm all in favor of moving toward hand counting. I absolutely am. And I like the fact what the original bill actually does here. Starts moving us in that direction. It's a change. And when you make policy changes of this size, we've got to do it in a wise and a graceful approach. And that's where I'm at on that. And I just wanted to make, again, one of the previous speakers spoke this as elegantly as it could have been put. Thank you.
Thank you very much, Representative. Any others for their first time on the amendment? First time? Seeing none. Second time on the amendment? Representative Riggins, second time on the amendment, sir.
Thank you, Mr. Speaker. I want to clarify. Paper ballots, I think, ought to be required. And I'm certainly not opposed to hand auditing tabulation and all that. I just looked at this and the way it was so widespread. I just thought that was an enormous step. And so absolutely. Thank you.
Asked you briefly there, Representative, but hopefully people pick that up. Representative Davis, your second time, sir.
Thank you, Mr. Speaker. You know, the other thing that we're not really considering with this is the economic costs. You know, our counties are already strapped for dollars, and elections cost dollars to facilitate. So at our county level, I'm not sure we have the funds available to do what this would call for. And then as far as the jury option, last time I was a jury, I was compensated for that, another added cost. So these are things that we would need to work through in order to possibly facilitate this going forward.
Thank you, Representative. Representative Haroldson, for your second time, sir.
Thank you, Mr. Speaker. Just a couple of things, just speaking to the kind of the 52 as we have it right now. People are saying we don't like that 5% this year conversation. I don't either. I wish we could make it reality this year for the full recounting of races. But again, it's a situation where last year, if we would have gotten this accomplished, that was fully in the works. So they're saying the changing of dates is bad. Well, the changing of dates, I think, is required and important to make reality out of this. And so the other thing that I would also say is bringing large third reading amendments that are substitute bills like this. One of the concerns I also have is there is no input from the populace at all. That is a concern. And I understand that a bill like this has gone through the system, and I understand that. But that is kind of the last minute fly blind effect. And so I definitely appreciate the passion, the heart, and the direction, and I will continue to work and fight on this as we move down the road on it. But I do believe that at this point in time, again, I would just ask for a no.
Thank you, Representative. Any other members for their second time? It's a pretty substantial list here. Brown, Washit, Larson, JT Connolly, Thayer, Brown, Landon, Lawley, Geringer, Locke, Williams, and Campbell. Don't want to miss anyone. Okay, going back to the bringer, Representative Brady, please bring us home.
Thank you, Mr. Speaker. There were a lot of comments, and I took some notes, so I'll try to address each one, whoever had said it. Regarding my testimony, I assure you, good representative, that I in fact wrote my own testimony. I didn't want to miss a word. Regarding large counties with thousands of votes, we can create multiple teams. There are teams of 4. 2 Republicans, 2 Democrats. It's very simple. I attended a 6-hour training that completed an entire precinct count in 6 hours in a very, very, very large multiple great count of ballots. Anyway, let's see. Regarding starting to count the votes, they do not begin counting until after 7 o'clock when the polls close and the doors are locked. That I'll say a western state along the ocean took 1 month with electronic voting machines to report that certify, to officially certify. Another comment was made regarding all clerks. They didn't want to see all 23 clerks follow the same rules. Yes, we do. Do we not allow, are we not as legislators representing all the various counties follow established rules? We apply the broad brush where we all have to follow our rules. 1 to 3% variance with hand counting. As we mentioned before, it's 100% accurate. We can't move forward unless there's every 25 votes are absolutely verified. Can't go on until it's until everyone agrees. Let's see, as to support that, when the good representative mentioned that when there was a hand count on a questionable county, that it was quick, effective, and accurate. The hanging chads, where you punch a hole in a card. No, this is filling in a bubble. And I might even say perhaps the hanging chad debacle was to usher in the electronic machines. Regarding county clerks, who this would put more on their plate, election judges are not the same as hand counters. And as I said, there is a national grassroots movement to see this through, and our state is very healthy on that as well. The more moving the needle too fast, I don't agree. This has been an issue for many, many election cycles. Economic cost. Have we considered the hundreds of thousands of dollars spent on each machine and how many are in each county? And those machines are not even in compliance as of today. Let's see. There was a comment on human error, and it was, again, going back to our issue with one of the counties. Yes, that issue was a human error with ballots, but the machine reads whether it's a human error or not. So, therefore, you will later be hearing another amendment on this bill, which does appropriate $300,000 to provide hand counting training to county clerks and staff to conduct hand counting of ballots, allowing training dates 7/1 of this year through 6/30 of 2028. But that 2-year goal bypasses this next primary and general election in 2026. That amendment does not go far enough, nor is it soon enough. Also, it determines that the clerk will appoint those who will hand count. It is imperative that the community.
Point of order.
Representative, what's your point?
I think we're talking about a future amendment, not the amendment we're on.
Okay.
Representative Brady, please keep us on the amendment that we're actually acting on, number 1.
All right. It's imperative that the community be part of this process to be involved, just like Election Day. When you drop your ballot into a black box, are you 100% assured your vote is properly and accurately read? I appreciate your attention to this matter by voting to support my amendment, make Wyoming number one again.
Thank you, Representative. Body, you are voting on third reading amendment number 1 to House Bill 52. All those in favor signify by saying aye. All those opposed, no. Amendment has not been adopted. Okay, ladies and gentlemen, we're going to take a break. We've got some things going here. Good majority floor leader, please.
Mr. Speaker, I move that the House stand in recess until 2 p.m.
Hang fire, ladies and gentlemen. Hang on. All right, no, we're good. So, ladies and gentlemen, what time, majority floor leader, what time did you establish for returning? 2 o'clock, okay. Any committee announcements? Representative Washington. Please.
Thank you, Mr. Speaker. Just a reminder, members, if you received an invitation to appear before the investigation committee, please respond to those invitations before the deadline this afternoon.
Thank you, Chairman. Any other committee announcements? Representative Knapp, Corporations, number 7.
Mr. Speaker, your Corporations number 7 committee will meet at noon recess in E005. We will continue discussion and comments on SF 82, duties of registered agents, and also discuss SF 41, engrossed, portable benefits accounts led by Vice Chairman Locke.
Thank you, Chairman. Chairman Byron, please.
Thank you, Mr. Speaker. Your TRW committee will meet tomorrow at noon recess, Tuesday, February 24th, in room E005 to discuss Senate File 24 and Senate File 124 engrossed.
Thank you, sir. Representative Baer, number 2.
Thank you, Mr. Chairman. Your committee number 2, Appropriations, will be meeting in 15 minutes in room 301 and online. We will be discussing Senate File 32, 911 funding, Senate File 10, engrossed, contracts for holding and treating mentally ill detainees, and Senate File 1, if time permits, and any re-referrals as assigned. We will also be meeting tonight upon adjournment in the same room and continuing our discussions on Senate File 1, and that is the general government appropriations.
Thank you, Chairman. Chairman Locke.
Thank you, Mr. Speaker. Your committee number 3, Revenue, will meet tomorrow morning at 8 o'clock, and we will hear 3 bills. Senate File 79, Senate File 80, and Senate File 39, and we will be in meeting room number 5.
Okay, very good. Thank you, sir. Any other announcements? Seeing none, you have heard the motion of the majority floor that we will stand at ease, recess until 2 p.m.